Good morning. The hearing on the espionage case and the legal and constitutional issues raised by Wikileaks before the Committee on Judiciary is now about to take place. We welcome everyone here to the hearing. In the Texas versus Johnson case in 1989, the Supreme Court set forth one of the fundamental principles of our democracy. That is, that if there is a bedrock principle underlying the First Amendment, it's that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. That was Justice William Brennan. Today, the committee will consider the Wikileaks matter. The case is complicated, obviously. It involves possible questions of national security and, no doubt, important subjects of international relations and war and peace. But fundamentally, the Brennan observation should be instructive. As an initial matter, there's no doubt that Wikileaks is in an unpopular position right now. Many feel their publication was offensive, but unpopularity is not a crime, and publishing offensive information isn't either. And the repeated calls from members of Congress, the government, journalists, and other experts crying out for criminal prosecutions or other extreme measures caused me some consternation. Indeed, when everyone in this town is joined together calling for someone's head, it's a pretty sure sign that we might want to slow down and take a closer look. And that's why it was so encouraging to hear the former Office of Legal Counsel, Jack Goldsmith, who served under George W. Bush, caution us only last week. And he said, "I find myself agreeing with those who think Assange is being unduly vilified. I certainly do not support or like his disclosure of secrets that harm U.S. national security or foreign policy interests. But as all the hand-wringing over the 1917 Espionage Act shows, it is not obvious what law he has violated. Our country was founded on the belief that speech is sacrosanct, and that the answer to bad speech is not censorship or prosecution, but more speech. And so whatever one thinks about this controversy, it's clear that prosecuting Wikileaks would raise the most fundamental questions about freedom of speech, about who is a journalist, and about what the public can know about the actions of their own government. Indeed, while there's agreement that sometimes secrecy is necessary, the real problem today is not too little secrecy, but too much secrecy. Recall the Pentagon Papers case. Justice Potter Stewart put it, "When everything is classified, nothing is classified." Rampant overclassification in the U.S. system means that thousands of soldiers, analysts, and intelligence officers need access to huge volumes of purportedly classified material. And that necessary access, in turn, makes it impossible to effectively protect truly vital secrets. One of our panelists here today put it perfectly in a recent appearance. He explained our problem with our security system and why Bradley Manning can get his hands on all these cables is we got low fences around a vast prairie because the government classifies just about everything. What we really need are high fences around a small graveyard of what's really sensitive. Furthermore, we're too quick to accept government claims that risk to national security, and far too quick to forget the enormous value of some national security leaks. As to the harm caused by these releases, most will agree with Defense Secretary Bob Gates. His assessment. Now, I've heard the impact of these releases on our foreign policy described as a meltdown, as a game changer, and so on. I think those descriptions are fairly significantly overwrought. And Mr. Gates continued, is this embarrassing? Yes. Is it awkward? Yes. Consequences for U.S. policy? I think fairly modest. So the harm here, according to our Republican Defense Secretary, is fairly modest. And on the other side of the ledger, there's no need to go all the way back to the Pentagon Papers to find examples of national security leaks that were critical to stopping government abuses and preserving a healthy democracy. They happen all the time. In 2005, the New York Times published critical information about widespread domestic surveillance. Ultimately, we learned of a governmental crisis that included threats of mass resignations at the Justice Department and outrageous efforts to coerce a sick attorney general into approving illegal spying over the objections of his deputy and legal counsel's office. If not for this leak, we'd have never learned what a civil libertarian John Ashcroft is. In 2004, the leak of a secret Office of Legal Counsel interrogation memos led to broader revelations of the CIA's brutal enhanced interrogation program at black sites. These memos had not been previously revealed to the Judiciary Committee or to many in Congress. Some feel this harmed national security, but to many Americans, the harm was a secret program of waterboarding and other abuses that might never have been ended but for the leak. And so we want to, as the one committee in the Congress that I have a great and high regard for, take a closer look at the issues and consider what, if any, changes in the law might be necessary. And I want to welcome this very distinguished panel. I've read late into the night, and I was awake most of the time when I was reading this, some really great testimony. And I'm so glad that you're all here with us. I'd like now to recognize my friend and ranking member, Judge Louis Gohmert.
Thank you, Chairman, and we do appreciate the witnesses here.